All right, guys. Todd Vandermeid from Freedom Steel. It's been a while. I've had some technical issues with the camera. I've had technical issues with the software. I hate Microsoft Windows, and on top of that, I've just been way busy out at the club. But there is a ton of stuff happening now. Here we are, 5 months post New York, and there's just all kinds of stuff dropping around us. So I'm going to try to knock out several videos on several topics that are popping up and around there. I've been in touch with lawyers from around the country about various different cases. So with all that, this video is probably going to run long. The government's argument in this case is 15 minutes, but I know that my commentary is going to stretch that out. So what I'll probably do is break this up into a couple of different parts to make it more bite-sized and easier to upload and all that. So the case we're looking at is Atkinson versus Garland. This is a gentleman who was convicted of a nonviolent felony over 20 years ago. He's trying to get his rights restored. It's an appeal. The circuit court in the 7th Circuit dismissed his claim. It is going up to the 7th Circuit Court of Appeals. I would point out that in this panel, you have Justice Sykes, who is the Chief Justice of the 7th Circuit Court of Appeals. You have Justice Wood, and you have Justice Scudder. These three justices are now dealing with an appeal about whether or not a convicted felon can have his rights restored and whether or not the felony prohibition as a categorical approach can be upheld in light of the New York decision. So with that, let's get a listen here, and I'm going to be stopping and starting the audio and interjecting my commentary on the fly so we get the minutia.
Mr. Soder.
Good morning, Your Honors, and may it please the Court. Kevin Soder from the Department of Justice for the government. I think it might be helpful to briefly take a step back. We're talking about a long-standing and critical piece of federal gun safety legislation under which individuals convicted of felonies are generally prohibited from possessing firearms.
It's not long-standing.
Well, the Supreme Court has referred to it as long-standing and has called out...
In dicta that is unexplained.
So I think
it's not long-standing by historical tradition. It's recent.
Mr. Soder?
Whoa. 20 seconds in to the oral arguments on the government's case, and he's being corrected and chastised for the way they are viewing some of the stuff in Heller. That sounds like Chief Justice Sykes. And she's right out of the gate saying it's not long-standing and it's not historical. They have taken the test that has been enumerated by Justice Thomas in the New York decision to heart. Right off 20 seconds in, they start talking about the historical analysis. Wow.
Let me ask you this question. In light of the dialogue that you just heard against the backdrop of Bruin, and I realize the timing here, when Bruin came down and the briefing schedule.
All right, quick timeout. The case is New York State Rifle and Pistol Association versus Bruin, who was the Attorney General for the state of New York. For whatever reason, a lot of people have taken to calling this the Bruin case. It's shorter than New York, maybe because it doesn't confuse it with something else. I like to refer to it as New York because it was the New York State Rifle and Pistol Association. We were referring to the other case of New York where New York City was trying to, they had a law on the books about how restrictive it was to transport a firearm. They changed it. It got mooted out. But I still refer to this case as New York. So in this, New York and Bruin are interchangeable. We're talking about the same case. I just prefer to call it New York.
And all that. Has the Department of Justice landed on the position that it's going to take in these cases? And that's part one. And part two, assembled the historical analysis that Bruin requires and submitted it to courts, or is that still all in the works?
Okay, so here we have a judge, judge number 2, Justice Scudder, sitting there talking about the historical analysis required by Bruin, New York. They're taking this to heart. They've read New York. They understand the implications of what Justice Thomas put down in the test.
So, Your Honor, to your first question, I want to be very clear that the Department of Justice's position has been and remains that Section 922G1 is constitutional in all of its applications. The historical record, we think, amply confirms that result that the Supreme Court has already suggested is the answer here and has said is the answer by referring to this exact type of prohibition as constitutional.
So the department's position, all the way up, including the Attorney General and the Solicitor General, is embodied in the red brief that was filed here?
So, Your Honor, I can't speak to the exact mechanics by which a particular
It seems to me, I understand the position, and that may well be the position, but it would seem that you would present it in a way that's not embodied in the brief that we received, and that's not a criticism at all. It's just an observation of the timing and the need to file a brief on the schedule that it was due here, but that it would seem that the department would step back and say, okay, this litigation is going on all over the United States in courts. It's going to work its way to circuit courts. What is our submission on, the historical inquiry that the Supreme Court now demands?
All right, so here you've got the judge saying Bruin demands a historical look back, history and tradition, to 1791. He didn't say 1791 in this one, and the Justice Department seems to just resting on their laurels that whatever historical gloss over was done under the old 2-part test, that's it, that's good enough. And this judge ain't buying it.
Well, Your Honor, I think in this case, our submission has been to make a few points that we think are particularly important to keep in mind. One is that the Supreme Court has repeatedly emphasized that the Second Amendment right belongs to law-abiding citizens.
That's a descriptive statement, not a prescriptive statement or a statement about the scope of the right. It describes what was going on in each of the cases. I think you're reading it for more than it's worth. We're clearly being told to do a robust historical analysis, to look for a historical analog to firearms restrictions post-Bruin. And my question is the same as Judge Scudder's. If what you gave us post-Bruin, in the red brief in this case, is the totality of the government's position on felon in possession statute for purposes of as-applied challenges, and this case isn't going to get any better on remand, we need to know that, and we need a candid answer. If you gave us everything you've got and you're not going to give us any more historical argument, then there's no purpose for a remand.
Wow. So they're willing to give the Justice Department, the government, a second bite at the apple on this. And I don't think this guy's getting it. If you're not going to do a better job, if all you're going to try to do is bootstrap what you've already put out there, then why waste our time? She's talking about an as-applied challenge, not throwing out the whole statute, but saying as the statute applies to Mr. Atkinson, it fails. I think they don't want to open the floodgates here, but let's go on.
Do you want the opportunity to do a better job on the history and not rely on the presumptively lawful firearms regulation dicta?
So, Your Honor, I'd like to clarify that we are relying on several things, including the history as an initial matter, which we do think that we have shown and other courts have adopted the rule that would resolve this case based on the history.
Before Bruin. There is no Court of Appeals decision after Bruin.
The courts of appeals.
She called him. They're trying to bootstrap up and act as if New York or Bruin didn't happen, that all the old stuff is still good. And she seems annoyed by it.
Appeals that have applied a text and history-based approach, however, that had a two-step framework resolved this at step one. And in particular, I would point to the D.C. Circuit's decision in Medina versus Whitaker, which held it only took that court sort of a few paragraphs to go through how the history supports a felon possession ban, particularly as applied to fraud offenders. And we think that analysis remains fully in force after Bruin.
You don't want another opportunity to develop a better historical record to subject it to adversarial testing in this case.
Your Honor,
we rely on the limited adversarial testing for the historical claim that has gone on before Bruin.
Dude, phone a friend. She's throwing you a lifeline. She's telling you we are willing to give you a second chance to make your stuff better because reading between the lines, what you've put on isn't carrying your burden, isn't getting the job done. She's clearly getting annoyed with this guy.
Your Honor, that historical record is compiled in the existing briefing. Of course, if the court believes that further material on these legal questions is necessary, we would...
She just told you that, you idiot. She just told you in no uncertain terms that all the stuff you're basing it on is pre-New York, and it doesn't hold any water.
Welcome an opportunity to address
My
that.
question is it going to get any better? Are you going to do the historical research yourself and give it to us? Or are you just going to point to that D.C. Circuit case and the multiple opinions in the Binderup case and so forth?
She is annoyed. If you're not... He can't read the room. They are throwing him a lifeline to get a second bite at the apple, and he's not getting it. The answer sort of said, yes, ma'am, we will certainly do a deep dive into this. Yes, we would relish an opportunity since the briefing schedule was so tight to the release of Bruin. Absolutely. But he's not getting it. He just ain't getting it at all.
Or are you going to actually take what Bruin says seriously?
Boom. Are you going to take what Bruin says seriously? My God. I mean, these judges understand the game-changing nature that New York is. And they're taking it to heart. They are truly taking it to heart from what I'm listening to.
Your Honor, taking what Bruin says seriously, I think, shows that the history supports a ban on firearm possession by felons.
I mean, obviously there's history in history, as the Bruin opinion shows, and I thought I just heard you say that if this court thinks that the history discussed in your brief isn't enough, you're willing to go back to the drawing board and fill it in more completely and show, what I was asking, are there any instances in which cases in the past or the history on which the 1791 drafters of the Second Amendment were looking at that shows that categorical exclusions are not okay? I mean, is there a necessary historical analog that shows you always have to have an as-applied safety valve, for example? I mean, you can break the questions down, in other words, into much more specific points, and you're not going to find something you're not looking for, but if you do realize that that the Bruin approach requires this deep and very granular dive into history, you're telling me you'd be prepared to do it.
That's the third judge who has gone back to referencing Bruin's requirement of a historical analysis. All three judges have now come out and said in this oral argument that the New York decision requires a review of the historical analysis to come up with something. And it sounds like all the prior New York decisions, the cases that were done under the means balancing, interest balancing approach, and were all found under intermediate scrutiny, and the government is simply trying to bootstrap that stuff up and is not having... The judges aren't buying it. They just aren't buying it. And this is the equivalent of the professor saying, your thesis sucks, I'll give you a chance to rewrite it. And they're begrudgingly saying, well, I think it's all there. This guy can't read the room to save his life.
Yes, Your Honor, I think that the important takeaway is that we think the history is very clear on this point and already
They're telling you it's not, you moron.
establishes
I
for the reasons
understand you
we've
say
explained.
that, but we're sort of playing around with the backup
but-
position here.
Mr. Soto, the other thing that I think that my colleagues have this right, that the layering and the nuance within the layers of these issues is pretty staggering. So one of the things that, I'll just speak for myself, that I would really benefit from, you're not going to like the premise, but if you're wrong on your main substantive position, okay, I think the judiciary would benefit immensely, and this court would, on what then? Okay, if there's no categorical exclusion and the limitation is on non-violent felonies, or the lines drawn around violent, how do you measure that? Are we looking just at the nature of the conviction? Are we getting into facts? Are we into the Second Amendment equivalent of the categorical and modified categorical approach?
And what does history tell us about all of those things? Because we can't make the decisions ourselves. We have to make the decisions based on
And there
some
seem to me,
version
I
of
mean,
history.
you could come up with a lot more examples than I can, I'm certain, but I think, well, there's a lot of non-violent felony convictions that one could be convicted of that would entail some violence in, at least as we think about relevant conduct. So take money laundering, where there's a gun enhancement, or obstruction of justice for threatening to kill a witness,
Wow. So this is a teachable moment, and this is something our side should take note of. So we're dealing with a felon in possession statute in general, which makes no distinction between violent and nonviolent felonies. So here the judge, we've already heard one judge talk about an as-applied challenge, so it's only fitting to this individual. But now Justice Scudder is talking about drawing circles around violent and nonviolent felonies and how do you define that. This is where our side, if you're going to tackle something like this, something like felon in possession, that you have to go in and give them a definition, give them an explanation within the pleadings, within the oral arguments. Say, Your Honor, we're talking about nonviolent felonies here. We're talking about somebody for tax evasion. We're talking about a felony DUI. We're talking about whatever. None of these had firearms involved, gun enhancements, anything like that. And we think that those should be treated in this way. And if you want to get to whether or not a person convicted of murder and later released can ever have their rights restored, I think that's another argument with another case, with another fact pattern for another day. Our guys need to think 3 moves down the board, anticipate this stuff, and have answers ready for it, and articulate that, and not give them this blanket, oh, you're talking about felons, and then take and lump murderers and rapists and people like that in with people who got, some hunting violations are felonies. So dealing with all that kind of stuff. And this is where we've got to be smarter than the other side. We've got to think 3 moves ahead, anticipate these kinds of things. Because now they've told us that stuff like this, when you go to challenge certain categorical bans, and that's something that's interesting. They start talking about categorical bans. Categorical bans generally come in 2 types. 1, the person's prohibited. 2, the guns that are prohibited. And they're very, very leery that categorical bans are, in general, are going to withstand scrutiny. When I say thinking about this 3 moves ahead, there are guys that want to undo the NFA. I get it. But if you're going to sit there and make an argument that the prohibition on machine guns with the Hughes Amendment and other parts of the NFA are categorically unconstitutional, there are going to be a lot of judges very skeptical and very skittish about legalizing machine guns across this country. They're going to have to figure out a way to parse that out and make them feel not so skittish. Whether you like it or not, you can stamp your feet, pound your fist on the table about the Second Amendment says shall not be infringed. But judges are people too, and they're going to have certain feelings, and they're not all gun. Very few of them are probably gun guys, and you have to get past that personal interbias feelings about the subject matter and the issue. You've got that here with felons. You're going to have it with DV cases. You're going to sit there and have it with things like machine guns and the other NFA items. And you're going to have to think those 3 moves ahead if you want to prevail or have some sort of modification into the realm of reasonableness on modern society.
And, we could sit here all day and list examples like that. So I don't know. I would benefit from how do you approach the measurement of this? Informed, of course, as Judge Woods emphasized, by the historical record.
Your Honor, I think that courts have appropriately recognized in all of the cases that have been decided about Section 922G1 that a class-by-class sort of categorical exclusion is appropriate, including this court in its Scoyan decision.
Well, yeah, but okay, the Supreme Court has reset the table.
Boom. Mic drop. This guy ain't getting it. A federal judge just had to clue in a government attorney that the Supreme Court has issued a reset. Dude, you're still trying to bootstrap and think you turned in what's likely a C- in terms of homework. The judges ain't buying it. They are trying to offer you and tell you how much plainer on do they have to make it that what you've turned in is inadequate for the position that you're in. How much more?
Right, and it now needs to be litigated anew under that framework. I totally understand the substantive position that you have to advance in the courtroom here. All I'm asking you to do is stand in our shoes for a second and realize what the Supreme Court has put in front of lower federal courts, and it is a daunting exercise that is multi-layered, that gets increasingly complex.
This guy is Justice Scudder here is all but pleading with the Department of Justice to do their homework. And I find this ironic because out in California, they are sitting there and arguing for a 6-month extension on several cases, the Duncan case, the Miller case, some auto bans, mag bans, in order to bring in historians and do that deep dive so they can try to claw back and hang on to their restrictions. And here you've got this DOJ attorney who's just trying to bootstrap up stuff that has been turned away. And this judge is saying it's a reset. There's a new standard involved. We have to look at it this way. Stand in our shoes because you didn't do your job.
And perhaps uncertain as you move through those layers.
And Your Honor, I think that's why it's important to take the Supreme Court at their word on the types of prohibitions that are permissible under their Second Amendment jurisprudence. And I think in particular footnote 9 of Bruin helps illustrate that in explaining why a shall issue licensing regime is appropriate, the court said the reason it's appropriate is that it helps ensure that arms are only in fact available to the law-abiding citizenry, and that only the law-abiding citizenry can overcome.
I don't think you can sign us up for just a broad endorsement of the presumptive validity language in Heller and McDonald after Bruin. I mean, good luck, but...
Good luck? You cannot sign us up for an endorsement of the presumptively lawful. Wow. That's an airstrike. That's a flat-out airstrike on the government's position. I mean, back in the day, we'd call it carpet bombing or an arc light mission with B-52s. Or this is a napalm strike that's come in and just roasted their position. It's amazing to me that the federal government in this case is just trying to bootstrap old case law that is no longer good and been tossed out. Either this guy is ignorant on the whole subject matter, woefully ill-prepared. I mean, you would think that reading the room, because he's not, the easiest argument would be, Your Honor, we would happily accept a remand for us to go back and provide the court with the information that you think you need to complete this decision. Done. We're done. Thank you very much. Any other questions? If I was getting my ass handed to me this badly, that's what I would be doing. That's what I would be arguing or asking for. They're going to give you a remand unless I'm going to assume that the vote at the end of this in the private justices' chambers is we have to give them a remand just so we gave them. I mean, otherwise, their decision is the government didn't appear like they were going to do a better job on another try. Therefore, we're left with the record at hand. And the record at hand is woefully deficient to meet the government's proof. I don't think they're going to do that. I mean, if they did, it would be a complete bitch slap to the DOJ and Merrick Garland and all these people. And I think that they're cognizant that they would probably doom this lawyer's career to do something like that. So I don't think they're going to do that. But he's not taking the hint. He can't read the room. And these guys are looking at it like it's a new day. I honestly believe these judges may not like everything that New York said, but they're taking it to heart. They're understanding it, and they're going to apply it faithfully. That's what I'm hearing between Justice Wood, Justice Sykes, and Justice Scudder, that they are now in a pickle. And this isn't a semi-auto ban case. This isn't a magazine ban case. This isn't the FOID card case. This is about convicted felons. And I think that's why they started off with this as applied, and then Justice Scudder got to violent versus nonviolent and all that kind of stuff, because they understand what the headlines are going to read. Felons can own guns. And it's going to do our side a lot of good to figure out how we draw those societal lines that are within a constitutional framework. Granted, the Second Amendment appears to be the only right you lose in perpetuity for committing certain offenses, unlike the First Amendment, Fourth Amendment, Fifth Amendment. But it's going to get interesting. So we are creeping up on 30 minutes here of video, and I don't want this to be so huge it takes forever. Not everybody has an hour plus to sit down at one point in time. So what I'm going to do here is we're going to stop here. This is going to be part one of Atkinson, and we are going to then dive into the second half of the government's case, get that up there for you, so it makes it a little bit easier. So guys, it's Freedom Steel. Please hit the like button, hit the subscribe button, share this on Facebook and social media and all that kind of stuff. We won't put misleading tags on our titles or anything like that, so you know what you're dealing with, and we're going to talk about this. We'll give you the straight scoop on stuff, and I'll give you my opinion is how this goes. So with that, please like, subscribe, support the channel. We're going to be doing a lot more of this stuff. There's been a lot of stuff coming out in the last week. And so this is part one of Atkinson. And as always, frag out.